Yeah, I thought what we'd start with is Lance will start with some organizational discussions on various types of entities. When Lance completes that, then I'll talk about the TX ramifications of various financial products, kind of have an update on some TX changes during 2010, and then Lance will speak further on exchange fee issues and a couple of other topical issues.
Okay. So what we'll start with is sort of the basic structures and options you have for structuring a trading firm. Again, I'll layer in a little bit of the tax because I can't, in my world, actually structure anything without thinking about Phil's world. So we'll layer that into the structuring. We'll then go back, talk about some terms you should consider once we've sort of picked the structure, and then we'll go on, as Phil said, to some of the regulatory issues, including the exchange fees. So, there's a couple different ways, but there's four main sort of types of structures you can have for a trading firm. The first is the obvious. Individual opens a trading account in his own name, starts trading in his own name. As a lawyer, that sort of scares me because as a lawyer, I never want anybody doing anything in their own name. I generally always want to put an entity in between the person and the creditor. So again, the benefit of personal is you don't have to talk to me, so it's a lot cheaper for you, and there's no administrative burdens. It's just sort of an individual forming, opening an account, putting money in, and starting to trade. If we move now to the types of entities, generally you're looking at corporation, an LLC, or an LP. Corporation, let's start with a typical C corporation. If you do a corporation which taxed as a so-called C corp, you're going to be looking at double layer of tax. So you're going to have an entity level tax on the income, and then you're going to have another layer of tax when you make a distribution. So no one uses C corps for that reason. The other option, which people used a lot before LPs and LLCs came out, was an S corp. An S corp is, from a corporate perspective, the same thing as a corporation, so boards of directors and officers. But an S corp has the ability to be taxed as a flow-through entity, similar to an LLC, so there's no sort of entity-level tax. There's only a tax on the shareholders. Now, the issue with S corps, which is why we don't really use them much, is that an S corp has limits in how you structure an S corp. So you can only have one class of member or one class of shareholder. You're limited by the numbers of shareholders, up to, I think it's 100 these days. And you have limits on having entities as your shareholders. So because of those limits, people who want to bring people in, give them different shares, for instance, have a trader who only shares in their own trading, that would be difficult to do in an S corp because it could be deemed to be a separate class of stock. So we don't really use S corps for that reason. They're just not flexible enough for us. So that really leaves for us two main types of entities, which is an LLC and an LP. So a limited liability company is what we use mostly, although we'll talk about why a lot of people used LPs in the past and are still in use. But there'll be a reason we'll get to why we're sort of not using those as much. An LLC, the benefit is you've got a single level of tax. It's a flow-through entity, so there is no entity level tax. It's extremely flexible. We can slice up the profits in the different classes of members and different rights and different obligations and different duties, for the most part, however we want. There's not a whole lot of limits on our ability to do extremely customized deals in an LLC. You can have a member managed, a manager managed, partly member managed, put in officers, managing directors, whatever you want, we can do in an LLC. Besides being able to do eat what you kill deals, which is, again, when I say that, what I mean is a trader getting only a piece of their trading profits. So even though the proprietary trading firm makes profits as a firm, the trader only gets a piece of their profits. You can do that in an LLC. You can split up your operating profits. You can split up your sale profits. Whatever you want to cut a deal, you can do in an LLC. Typically, we use Delaware. We don't really like to use Illinois LLCs. And the reason for that is under Delaware law, you are, for the most part, not restricted in how you cut your deal, and you don't have any sort of self-imposed duties statutorily. The only duty you have that you can't contract around is the duty of good faith and fair dealing. So there's no implied fiduciary duties. You can sort of contract around. So if you want to have one class of members that has full duties to the firm and another class of members that has, in effect, no duties except for good faith, you can do that in a Delaware LLC. In an Illinois LLC, you cannot do that. Illinois still has a statutory provision which says that the management, so in a manager-managed LLC, it'd be the managers or the members in a member-managed LLC, you cannot contract away their fiduciary obligations. So for a trading firm, that becomes an issue because in most firms where they have sort of the A members and the B members, where the A members are sort of the founders or the management who put the money in, and then the B members are the members who typically trade and get a piece of the profits, the A members don't want to have a situation where the B members could sue the A by saying, well, what are you doing outside of this entity? Why did you do that trade over here when you could have put it in this entity? And under Illinois law, they may have a claim. So we don't really use, as a firm, Illinois LLCs for that reason. Now, the cost to you to use a Delaware LLC is you then have to typically qualify to do business in Illinois because you're Delaware and you're doing business in Illinois. But that's sort of couple $100 a year cost, and in our view, it's well worth the cost because one little problem with a lawsuit and that cost is going to seem negligible. So that's sort of the LLC. The LP is another option, a limited partnership. LPs were used a lot because there were no LLCs 20 years ago. So you often saw LPs and people didn't quite know what an LLC was, or they weren't comfortable that the law was settled, and so they went the LP route. Eventually, people got comfortable with LLCs, and the benefit of an LLC is if you're the manager, you have limited liability by statute. So a manager does not have unlimited liability. In contrast, in a limited partnership, the limited partners have limited liability, but the general partner has unlimited liability. They are, in effect, if that entity blows up, whoever the creditors are can go to the GP and require the GP to make up the money, in effect. So what that does from a structuring perspective is requires us to form another entity to be the GP, because obviously we wouldn't want an individual to be an individual GP and someone individually guaranteeing the entire firm. So it requires another entity. The reason why you still saw a lot of LPs in the trading industry is mostly because of self-employment. And Phil will get into that a little bit, but most trading firms want to limit the self-employment tax that they pay. And what I mean by that is, you obviously you cap out on some of the employment tax, and you get, what is it, 2.9% now?
2.9 and 15.3% up to 107,000.
Right. But the 2.9 is the uncapped. So
it is.
Obviously, if your firm makes a lot of money, 2.9% of a lot of money is a lot of money. And so what people had done in the past is they would take the position that I am sort of a founder and I'm on both the management side. I own a piece of the GP and I'm a limited partner. And under sort of old tax law, generally limited partners in their positions as limited partners were exempt from self-employment income. So what you saw is a lot of firms saying, all right, well, I'll pay self-employment income on one side of the equation, but not on the other side. And so that's why, although from a corporate perspective, I prefer an LLC, you still saw LPs being used quite often. That, for the most part, is going away for two reasons. Number one, in, 2013 when the Hire Act comes in?
Yes.
I think 2013, the whole distinction between a limited partner and a general partner, an active partner, won't matter anymore because that 2.9 is going to go up to 3.8. 3.8, and that 3.8 will be assessed on what is in effect investment income. And that investment income will include...
Or earned income, either way.
Right, and investment income, right, will include securities and commodities?
Correct.
So your structuring won't matter because they're not going to care about who receives the income, they're just going to tax it.
Interest and dividends.
Right. And so that's a 2013 issue. A current issue is that there are cases out there now that have come out recently that basically say, well, we're not going to look at whether you're just a limited partner. We're going to look at, are you actually providing services? Are you really getting an allocation for services, or are you an investor? And we're not going to sort of look at the mere fact that you've called yourself a limited partner. And they'll probably be looking at how much money do I have in versus how much of it is this attributable to service. And we don't know how those cases will turn out. The the case that came out was with a law firm where no one puts money in, no. It's with a law firm where, in effect, they didn't fund much into the law firm, and everything, all of the income was attributable to services. And so the case said, we don't care that you think you're limited partners, it's all attributable to services. So I think for those reasons, we're not necessarily seeing a lot of LPs anymore, because again, from a corporate perspective, there's an advantage to a corporation. The last thing from a structuring perspective is whether you've gone with an S Corp or an LLC or an LP, what we typically do for a trading firm is you can go simple and do a single entity. Then that single entity has all the money, conducts all the operations. The problem is that if that entity has a problem, so it has a trade that blows up, anything in that entity will go down with the ship, so to speak. So what a lot of our clients are doing is they're not only, there's some clients that still trade sort of on a point-and-click basis in their head, and so there may not be any tangible IP. But a lot of our clients have significant tangible IP, whether because they're high frequency and they have, they have black box or connectivity or whatever, or they're gray box, or they have some tangible tool that helps them trade. If everything is in one entity, and that entity has one bad trade and it goes down, all your IP goes with it. So what we typically do is we'll set up a holding company, and that holding company will own two companies. One will be the trading firm. That'll be the one where the trading capital is. That'll be the entity that signs the clearing agreement. And then we'll set up another wholly owned sub. That'll own all the intellectual property, and that entity will license the IP to the trading firm, under the hope that you keep only the amount of income or cash you need in the trading entity, keep the excess cash up at the holdco, and so if you have a problem, this entity goes down, but we have excess cash up at the holdco that's protected, and we have intellectual property that's protected. So hopefully there's enough there we can sort of go forward and start trading again. So that's sort of the basic structure. We have obviously create many entities for different types of trading, but your basic structure is two entities plus a holdco. You want to get into the tax impacts?
I will. We'll start with, basically you have two types of income and losses. You have ordinary losses and you have capital losses and capital gains. If you have a long-term capital gain, it's taxed at 15%. If you have a short-term capital gain, it's taxed the same as ordinary, which, as we speak, the top tax rate is 35%. We'll talk about self-employment tax in a minute. In 1981, to curtail tax shelters that were being sold to the retail public, Congress passed Section 1256 of the IRS Code. And it basically said for regulated futures contracts and a few other products, by definition, 60% will be long-term, no matter how long you would hold this particular position, and 40% would be short-term. That gave you a blended rate of 23%. But along with this beneficial rate, you would have to mark your positions to market at year end. And this was the first time Congress ever looked at marking positions to market at a year end and being taxed on that unrealized gain or loss. They added some other products over the years. In 1983, they added equity options traded in a market maker account. And basically a market maker account would be a member of an exchange. They also added broad-based index options, OEX, for example. They also received 60-40 treatment, and at year-end they're marked to market. And also currency forwards, where the underlying future is traded at the IMM. And the last item that they added was single stock futures, if they're traded by a professional. If they're traded on a futures exchange, that would be a member of an exchange. If they were traded on a securities exchange, it would be traded by a market maker or a specialist. This 60-40 is a tremendous advantage, because if you think about it, your gross is taxed at 60-40. But many of your expenses are ordinary, and so they would offset the 40%, which you're being taxed at 35%. So a large trading entity that has many employees, and we'll talk about the various ways to pay traders in a minute, that those ordinary expenses would offset the 40% short term. And as a result, the owners of an entity would pay tax roughly at a 15% rate. Remember, you may be paying a trader 50, 60% of what he makes, but he's being paid as salary. He might be being paid as an ordinary or as an independent contractor, which we'll talk about in a minute, but that's offsetting the 40% that's short term. One of the other nice advantages.
Sorry to interrupt, but you're for the futures, they're only futures based on U.S. exchanges, correct?
No. Now we have, besides Bermuda and Montreal, which have always been part of 1256, but never traded, that we have the CIMEX, the ICE, Dubai, and Life. We have the futures contracts traded on those exchanges. There's other products that trade on those exchanges. We do not believe that they fall under 1256.
So
Sorry to interrupt again, but while we're on that subject, what if you trade basis? So you've got cash bonds on one side and futures on the other.
You have a mixed straddle, which we'll talk about in just a moment.
But again, the IRS can make a determination, which it has, on foreign boards of trade and choose, as Phil said, to give them credit and in effect say that those are eligible contracts for 1256.
And up until a few years ago, that they had not approved any exchanges. In the last 4 years, all these exchanges have been approved.
Eurex is not approved yet, are they?
No, not yet. The other nice thing about Section 1256 is that you can carry the losses back. Any other capital gains, you only have the ability to carry them forward. But futures, you can carry back 3 years, 2 years, 1 year by amending those prior year returns if you would have a loss in the current year. Okay, now, when you trade a 1256 product in conjunction with a non-Section 1256 product, you have a mixed straddle. If you make a mixed straddle election and you keep track of the gains and losses every day and net them, at the end of the year, you can take as much as 50% long-term and 50% short-term gains, assuming that the gain is on the derivative side, not on the cash side.
So that's an incentive to make money in futures?
Very much so. And that again, that you see that, you know, that if you're doing a treasury basis trade, exactly. I mean, that you would always try to do that. Okay. And
so what would be the mixed rate of tax rate?
Well, it would depend. Let's say, for example,
if you lost all your money.
If you lost all your money, the short-term loss can never be more than 40%. And if you can think of it, you always want short-term losses and long-term gains, because those short-term losses offset other short-term gains you may have from something else. But under the mixed straddle rules, that short-term loss can never be more than 40%, and the long-term gain can never be more than 50%. And the mixed straddle election has to be made before you trade these products. Coupled with, it's pretty common to have a mixed straddle account and a regular trading account. So in terms of if you're trading treasury futures along with cash treasuries, the treasury futures would go into XYZ mixed straddle account, and the other trades would go into the other account. Now, there may be, if you're trading other than regulated futures contracts or Section 1256 products, you may want to make a 475 election. What a 475 election is it marks the position to market. what a good example, or a good example of someone who would want to make a 475 election is an equity trader that will never hold a position for a long position for more than a year. Under Section 475, the account is marked to market at year end, and the gains are ordinary versus capital. At best, they would probably be short-term capital gains. By having them ordinary, you have the ability, if there's a loss, to offset other ordinary income. And if you have an overall loss in all of your ordinary income, well, then you could carry it back 2 years.
And the reason they would do that is also that the matching rate is a problem for a lot of
The
firms?
matching's a problem, and also the wash sale rules.
Right.
And it makes the accounting very easy. And you're really not out anything if you're, that if you trade for a short-term position. The only thing you're out is paying tax on the unrealized gain.
The thing to be careful about is if you're generating 60-40 income on equity options because you're a dealer, then there's a sort of a guesstimate as to how much, where my profit's coming from, the equities or the options. And I've seen clients make the 475 because they sort of guessed it was coming from the equities. Lo and behold, it's coming from the options, and they've sort of given away the 60-40 treatment. And then there's some structuring. We have to start new firms in order to get away from that. So it's a forever election, right?
We have never seen the IRS let somebody out of an election. Right. The election has to be made by April 15th of the first year's tax return.
A lot of hedge funds will make the election because their investors, if they have U.S. and non-U.S. investors, they're making the determination their investors don't care. And even on the equity side, they're not getting 60-40 on the options because for tax reasons, the non-U.S. people won't want to invest in a broker-dealer in effect because it's a tax issue for them. So they'll make 475s regularly, and I think it's a little more of a challenge to make sure you're right on the prop side.
And and even if you make the election, you can still have an investment account, but you have to put the particular security in that account by the end of the day. So if you're a prop equity trader and you basically trade all day, but there's a certain position that you believe you're going to hold, well, then you would put it in a separate account, and that account is referred to as an investment account. Maybe now we can talk about how we pay traders. The first, that there's basically 3 ways. The trader can be a member of the LLC or partnership. And as Lance spoke of sub-S corporations and C Corps, we never see them. I mean, people don't use them anymore since the advent of LLCs. An LLC is set up usually by equity members, and then they would bring traders in. The trader would want to come in because then he would avail himself to the 60-40 treatment. If you have a trading entity, you don't especially want them as equity members. But on the other hand, if I'm the trader, I see the 60-40 advantage going to you instead of me. And if I'm making a lot of money, there's a good chance that I'm going to bring it up. That there really isn't any issue there other than legal issues that most are set up with a Class A member who were the equity members and other Class B members who have very little rights other than to their money. Their allocated income, they receive a K-1 at year end. The next type of way to pay a trader is basically with a W-2. And it's like any other salary. There's withholding, that it's ordinary income to the trader. The firm pays the employer payroll taxes, which are a cost. The third way is to pay a trader as an independent contractor. And this gets into the employee versus independent contractor rules. And it's very risky. That you have to show that the trader is truly independent of your firm. If the trader is allowed to trade for other trading firms, that would lean towards him being an independent trader. If he would sign a trading agreement with your firm that has some covenants not to compete, has some confidentiality issues. You set most of the trading parameters. That would lean towards the trader being an employee. It's basically a control and direction issue. If you're controlling the trader, if you're setting the direction, and if you treat him as an independent contractor and give him a 1099-M and you're audited, there's a good chance you're going to lose. And the IRS will come back and they'll ask for the payroll taxes that should have been paid.
And the way most of my clients view their traders or their quants or their developers is the idea that I say in order to sort of 1099 them, no restrictions on their ability to do anything, you know, no exclusivity, they can go trade for others, they can develop for others. That tends to be a deal breaker. And so the idea is if the cost is, as Phil said, is half the employment taxes, usually that's money well spent.
Yeah, it's 7.65% up to 107,000, and it's 1.45% after 107,000. And what makes it even worse now is that, as you can imagine, the IRS pushes people towards hiring traders as employees as opposed to treating them as independent contractors. They even came out a few years ago with a form that if I treat somebody as an independent contractor and he's filling out his taxes, he realized now he's paying 15.3% instead of having 7.65% withheld, he can represent that he was really an employee. And needless to say, he has to put down his firm's tax ID number, and I can assure you that this firm will hear from the IRS. Or that what we've seen is a trader is treated as an independent contractor. He leaves the firm, he's disgruntled, he feels that he was underpaid, but it's an acrimonious situation, and the first thing he says is, I'm going to turn you into the IRS because I was really an employee and you treated me as an independent contractor.
You know, the other way he figures out is he goes for unemployment, and they tell him, you're self-employed, there's no unemployment here. That's the other time they figured out.
They are, and we had a case where the independent contractor acknowledged in a written agreement that he was an independent contractor, and the firm still lost.
Can you go over the additional burdens if a guy that you've been treating as an independent contractor now has become an employee? Tell me.
You have to pay Social Security and Medicare, the employer portion, and that's 7.65%.
Total between the two.
Yes, up to 107,000. Then after 107,000, it's 1.45%. If somebody is self-employed, they pay all of that.
You pay them gross, and you don't have to withhold. So the benefit of the independent contractors, not only does it not cost you anything, you don't have a withholding obligation.
Coupled with, if you have a pension plan, you don't have to include them in the pension plan if they're an independent contractor. But one advantage for the trader, who would be an independent contractor, is he could put as much as $49,000 into a SEP retirement plan himself. I'd like to just talk about a couple of items that are on the horizon. And they were included in the budget that the president sent out of Congress last week. And there are a couple of items that have been around for a while. One of them is carried interest. Basically, carried interest says that if you have a trading entity or any type of an investment entity, and there's that if somebody's receiving an allocation of profit other than in a pro rata manner based on his capital, well, then it's ordinary income to him and it's self-employment income. That this carried interest issue passed the House a year and a half ago and it never got any place. We don't think it's going to get anywhere this time either.
Yeah, and the thing to be careful about is I think most people view carried interest as sort of a hedge fund issue. So they hear about it, and it actually came up really in the hedge fund and the private equity world. So their incentive allocation, the private equity guys are getting all long term. The hedge fund guys are getting the flow through, and we want to stop that. The issue is that a incentive allocation is just a profits interest. It's an interest granted for, in effect, the provision of services without capital. Well, your Class B deal with a Class B trader who says, I want to become a member because I want 60/40, and they get an allocation not because they put money in and not based on their money, but based on their profitability, is the exact same thing as incentive allocation. And so, in effect, the prop firms got wrapped up in the hedge funds without necessarily Congress realizing it. So that's something to watch, because although it's been framed as a hedge fund issue, it's very much a proprietary trading firm issue. But again, it hasn't necessarily seen the light of day again in the Senate.
Yeah, and we don't think it's going anywhere this time either.
Now it may flip now to the House, but yeah.
Yeah, that when Lance and I did this presentation a year ago, this issue came up, and it's when the carried interest was a different issue because of the control of both the House and the Senate. And even there, I reminded everyone that 2010 was an election year, and we still have the best government money can buy. So
the other thing you should do is, it may sound like blasphemy, but thank Mr. Dodd and Mr. Frank, because although from a regular's perspective everybody dislikes them, they took up so much of their attention there was just no time to deal with carried interest. So in some respects it was a nice shield.
Yeah. Another part of the president's budget is commodity dealer legislation that would basically do away with 60/40 treatment for futures trading for commodity dealers. Commodity dealers is defined in the code, in the regs, is someone who trades on a membership. Again, we find it hard to believe that this legislation is going anyplace.
In the
And
near future or even
Anyone who
longer
owns
term?
a seat, you're saying anybody who owns a seat.
we would define a commodity dealer like that. It's not that clear.
It's come up in the self-employment context.
It
right?
has. It has. In the self-employment context, is that if you're trading on a membership for your account, that it's self-employment income because you're a commodity dealer. And again, that if you go back to the self-employment rules, they say it's someone who's registered with an exchange, which the IRS has determined to be a member.
Right. There was a question as what is registered with an exchange, meaning that makes sense in the equities world, doesn't make a whole lot of sense per se in the futures world. And so the case, in effect, said, oh, well, we view that to mean you're just a member of the exchange. So for the most part, anybody who's a member, which is anybody, a lot of people trading with any volume, are going to be stuck with this.
What if it's an LP with several members with seats?
If it's a limited partner, it's that the regs, that it's a gray area, but if it's a limited partner, they may not have a self-employment issue. Or are you talking about the commodity dealer part? No one knows because it's not law.
But you don't feel like this is actually going anywhere, do you? I mean,
Not at all. Not at all.
Okay.
I mean, I think we'll be sitting here a year from now, and it still won't. I mean, I honestly don't think you're going to see any major tax legislation for the next 2 years.
Yeah, after Obama sort of made his compromise, I think most of this is dead for 2 years. He still probably felt obligated to put in his budget, sort of help his base, but probably settled the issue for about 2 years.
Also coming up is what Lance made reference to, that in the health care bill they're going to add another 3.8%, either as self-employment income if it's that is self-employment tax if it's self-employment income, or if it's investment income, another 3.8%. That's for families that make more than $250,000 or individuals who make more than $200,000.
Now, there has been chatter about people thinking there's a chance that actually gets repealed or changed.
Or the Supreme Court saying it's unconstitutional.
Right. So the whole idea of, well, should I do an LP because it's going to go away in 2 years, and is it worth it for 2 years? There's always sort of, first of all, I'm not sure the LP play works per se, but if you think it does, you've got this idea, well, it's going away in 2 years, not worth it, or maybe they'll change the law and it'll come back. So sort of in that middle ground right now where it's unclear what's going to happen.
I mean, if you looked at a worst case scenario 2 years from now, ordinary rates would go up to 39.6%. You would add 3.8% to that, and now you have a 5% Illinois tax. So your marginal tax rate would be about 49% in this state on ordinary income. That's why if you look at Section 1256, you know, it's great. I mean, it's a windfall. I gave a presentation to some Japanese folks from securities firms in the 80s, shortly after Section 1256 passed, and they just couldn't figure out what, you know, like why it was 60-40. And I tried to explain to him it was just a negotiation point in Congress, and that there's no analytical methodology that to give a future 60% long-term and 40% short-term treatment. Finally, I couldn't get through to him, so I just said the chairman of the House Ways and Means Committee, the committee that writes tax laws, is from Chicago. Before the translator could translate it, these Japanese folks go, Rostakowski! and it's pretty much the case.
Now the equity options guys are still trying to figure out what happened to us. Why do we have to be dealers and these guys get it regardless? So they're still not quite as happy with the compromise as the futures guys, but you know. So Phil talked about the sort of ways in which you now bring employees on or traders, and the one thing as the lawyer is generally no matter how you bring them on, if I was you, I'd have some sort of agreement with them. And that agreement will take a different tack. The benefit of an agreement is the obvious, is that it's clear as to what the deal is. See a lot of lawsuits from traders and from quants and from others basically saying, you told me I was getting X. You promised me this, you promised me that. We had an oral agreement, and you know that's sort of a, you know, one person's word against the other. And in court, you know, my job as the lawyer is to prevent anybody getting to litigation, because as much as people may think we're overpriced at the front end, we are way more overpriced at the back end. Litigation is much, much more expensive than getting it done right at the front end. So I have some clients that would spend a little money on the front end, not get a great agreement. They come to me in a litigation, and we sure wish we would have got it done right. So my advice is get it done on the front end, make sure you have a clean agreement, avoid litigation. It's way too expensive. And then what you're left with is seeing the legal fees mount, and you're thinking, I might as well settle even though I have a great case just because I got to keep paying the lawyer. So again, the idea is to have a tight agreement that if someone goes to another lawyer, and there's always lawyers out there that'll take the case, that the lawyer even says, we don't have a winner here. I'm not wasting my time. I'm on contingency. It's very clear you're not going to win. That's when you represent the firm, that's the position you want to be in. So the agreements take various forms. If you're an employee, generally we would say let's do one of two things. Either for a trader that sort of has a specific split, let's do an employment agreement. Let's sort of set forth their duties, their obligations, sort of any restrictive covenants like non-competes or non-solicits or non-disparagements, non-collusions, come up with a whole bunch of different types. Let's get the intellectual property deal down. Do we own it? Do they own it? If we own it, do they have the right to use it? Very important, and most important is let's get the economics down. If they have a specific deal that says I get 50% of the profits, and people have written letters that say 50% of the profits, well, profits means a lot of different things to a lot of different people. Does it mean gross trading? Does it mean net? Does it include sort of connectivity, data fees? Does it include membership costs? Does it include overhead? And so the idea is to get that down up front, not have litigation on the back end. We suggest that for a trader. For quants and for developers who aren't really as specific on the deal, on the economics, where maybe it's a base and a discretionary bonus, maybe doing a full employment agreement is a little bit of an overkill. And so what we would then suggest is you do an offer letter that sort of sets the basic terms of the employment relationship, most importantly at will. You can fire the employee at any time. There's no severance. Here's what your general benefits are going to look like. And then we will go with a shorter, what we call a restrictive covenant agreement. It will also cover, you know, intellectual property, confidentiality, non-solicits, non-competes, but it's done in a manner that's maybe a less intimidating for people who aren't really used to signing agreements. So that's sort of for an employee. For an independent contractor, it looks, if we can do it and Phil says it's okay or doesn't say it's definitely not okay, we'll do some sort of trading agreement or independent contractor agreement. But again, same issues, right? Same issues. You want to make sure you document the deal to avoid litigation. Where the real sort of meat is let's say you decide I want to put a trading firm together, and I'm either going to have more than one equity partner, so let's call it founders, 2 founders come in, and maybe I'm going to have traders that have convinced you that they're going to trade big enough and they want the 60/40 and you've agreed to do that. Now we've got an LLC agreement. And what I like to do is I don't like to have multiple agreements because quite frankly people lose track of them. So my LLC agreements are sort of a combination of an LLC agreement and an employment agreement. So let's sort of put all the deal terms in the LLC agreement and make sure the whole deal's in there. The benefit to the firm, besides having it all in one place just from an administrative perspective, is people are worried about non-competes and non-solicits. They're worried about, are they enforceable? And they generally are enforceable, but some people go a little too far with them and they're worried whether they'll be enforceable in the employment context. The benefit of putting them in an LLC agreement is generally, if they're in an LLC agreement, my documents will say they're governed by Delaware law. And it'll say they're not governed by employment law, they're governed by LLC law. And again, my starting point was Delaware will tend to enforce what is in the agreement. So if you wrap all your covenants in an LLC agreement, you have it governed by Delaware law. Again, not to say a Delaware court won't put their sort of labor hat on and think this goes too far, but in my view, you have a better chance about getting those covenants enforced if it's wrapped in an LLC agreement or a partnership agreement. So the things to think about, there's sort of 10 topic areas every time I do an LLC agreement that I run through. The first is capital, who's putting money in, who's not, who's obligated to put more, does the firm have the right to accept more, that type of thing. The other thing is obviously percentages. If I put money in, do I get a percentage based on the amount of money I put in? Or do I get an extra percentage like an incentive allocation? So 50% is split based on how people trade, 50% goes to capital, and obviously anything in between. The other thing, as I mentioned, is we can split up the income. So some people get a split one way on trading income, other people get a split on operating income, which in the trading firm might include license fees. There's some firms that will create their own intellectual property, determine, hey, this is great, we can license it out to third parties. The licensing out of that IP won't hurt us as a firm, maybe because we don't think people can use it the way we can, or we'll sort of license out a watered down version, but you may see license fee income come into the firm. And then the last thing is, if you sell the firm, the sale profits, which is really the big bang hopefully at the end, those profits are often split a different way than everything else. So again, in an LP and an LLC, you can do that. What we tend to do a lot on the deal where we have a Class B trader is we will set up a framework so that the Class B trader has certain covenants that they are bound by in the LLC agreement. So the non-solicit, the non-compete, their duties. But then we'll have what we call the supplemental trading agreement, where we will put the exact business terms of each trader in a separate agreement. And the reason for that is, as a firm, no firm wants every trader to know every other trader's deal. Right now, we all assume they'll figure it out, but we definitely don't want to put it in lights. And so by doing this separately, you can, in effect, protect the confidentiality of every deal with every trader. And there are reasons why some traders get different deals than others. By setting up this framework, again, we have confidentiality. We have the base agreement. We put everything in another agreement. And that agreement can deal with things like their split, their duties, their holdbacks, how much notice they have to give to withdraw, when they'll get paid when they withdraw, how we're going to mark their positions. Any number of things, that deal can be customized trader by trader without having to sort of give that deal to everybody. So we do that a lot in the Class B deal. But we shouldn't overlook the fact that if you come together with more than one founder, you also want to be very clear on the sort of respective duties and obligations of the founders, because for the most part, two people come together to build a firm. The expectation is, both founders will devote all of their time to that business and are building it together. Well, as often is the case, one founder does that. The other founder tends to not be in the office as much, tends to like to be on vacation, and you get a situation where they've built a nice firm, but the one founder's doing all the work, and the other founder's out somewhere on a beach.
You especially see at Lance where the firm has been very successful.
Yeah,
And
the beach
all-
becomes more palatable at that point.
And affordable.
Nicer beach. And so that's not a great position for founders to be in because there was an expectation of what the deal was. And so what our LLC agreements do is set that deal up front. So if a founder is not satisfying their duties, typically we will have the right to repurchase the founder. This is usually at a startup phase. I'll tell you what we do for an established firm, but at the startup phase, the firm's not going to be successful unless the founders are doing their job. Same thing with your Class Bs. Class Bs, whether you're on an eat what you kill deal or you set up a Class B so that's sort of like a junior partner, people are given equity not necessarily because they're investing, but because we want them to incent them to do their best for the firm. If they no longer do their best for the firm, we don't want a situation where we have all these partners that we can't claw back, because what's going to happen is we're going to need to replace those people with someone else, and we don't want this huge sort of overhang of equity. The other thing is if you don't have good repurchase provisions, when that person leaves, if you don't have the right to take them out, they're often going to one of your competitors. So now in the worst situation, we have someone who's at our competitor that still knows what we're doing and has our economics from our firm. So you want to be very careful to make sure that you have very clean sort of buy-sells. We will set things like who's the management. If I've got 2 founders or 3 founders a little easier because often management's run by the majority, makes it a little easier. If I have 2 founders, makes it a lot more difficult. Generally the founders don't have to agree on day-to-day, but on anything material, they generally are agreeing on it. Now the big question is what happens if they can't agree? For a lot of firms, the answer is they don't do it. Okay, and for other firms, they may say, listen, we need a provision in there that if we just have sort of an irreconcilable difference on a major issue, we need a way to sort of move on with the firm, and we'll put in limited situations what's called a Texas shotgun. And what that provision says is if there's sort of a material decision, like let's say selling the firm. Classic example, one founder is sort of realistic, this firm isn't going to double like you think it is, let's sell, we've got a decent price, let's sell. The other founder says, no way, this firm's going to double, let's not sell. We'll have a provision that if they have a good faith disagreement, there's different variations, but often one founder throws a bid out, the person who disagrees throws the bid out, and then the other one can either put or call. And so obviously, whether you're the one putting the number out that you're going to be willing to buy or sell at is sort of, you don't necessarily want to be the first mover, but it's a way also to bring people, quite frankly, to the table and come up with a reasonable solution, because that Texas shotgun is pretty draconian, especially if you're the first mover. So there's ways to sort of deal with the 2-founder issue. Often we have, again, we set forth duties. We make clear either founders have full-time, or there's many deals where one founder's really there to be day-to-day and the other founder's there really more strategic. We'll document that. We'll make it clear that one founder doesn't have to devote full-time so that he's not in a position where he's doing what he thinks he's supposed to do. The other founder says, well, you're not here every day. And we said, well, 10 years ago, we agreed that wasn't the deal. So again, it's another way to get the deal set up front. Again, everything I talked about from a non-solicitor and intellectual property, all that we tend to bake into the LLC agreement. The price, so now let's assume we get all the way to the buy-sell and we have a situation where we have to buy someone out. For a non-founder, typically we advise, and it's in our view market, that the non-founder comes in at book and out at book. What I mean by that is their cap account balance.
Based on generally accepted accounting principles.
Exactly. Yeah, generally, yes. Yeah. And what we want to avoid is that if you quote, say, fair market value, one person's view of fair market value can be wildly different than some other person's view. And if you've ever been involved in litigation, trust me, you will find one expert that says it's worth nothing and one expert that says it's worth $1 billion. And so that's a tough lawsuit. So often, we don't want to be in that position. We want to say, listen, we know we're worth Y when someone actually writes a check for it. Before that, it's pure speculation. And if rumors are proprietary trading firm goes public, they have a great IPO, that sets the mark. That's exactly what the trader's going to say. And most firms in this market believe that firm is worth book until someone writes them a check otherwise. So we like to sort of put that in there, be clear. If people believe, well, I have to take people out of fair market value, whether because they're a founder, and you can argue founder getting out at book when he's been there for 10 years, is a little harsh for the founder. So what we often do is, again, there are some deals where people will go to an appraiser. But again, in my view, that's sort of playing the lottery a bit because you have no idea what that appraiser is going to come back with. What we'll do more often is sort of get a little more quantitative, and we'll put a formula in. So we will set what we believe is a reasonable estimate of what fair market value will be. Tends to be set a little bit lower. So we may say it's 3 times EBITDA. Let's just set it at that. We understand it could be a little higher, could be a little lower, but it's a good estimate. And then we know we're not going to have the lawsuit per se. They still have a lawsuit, but hopefully not on that. And so we have something that we can plan for and know what it's going to be. When we do multiples of EBITDA, one thing you want to be careful about is some firms have learned the hard way, you don't look back just 12 months, because guess how many people retired in 2008? A lot. A lot of people said, oh, this is a great year for me to be out. Oh, we're 3x of, oh, the best year we've ever had in the history of a trading firm. And so what you want to be careful with that is generally we'll smooth it out by looking backwards, whether it's 24 months and even sometimes looking forward, 12. And because a lot of people will also see, I like my trailing, I think maybe my competitive advantage is about to go away, let's get out now. And then the other person's sitting there, sort of left holding the bag with a firm that he just paid out on a nice multiple, and now he's left with declining revenue. So often we'll look forward and try and smooth that out and pay on that. And again, there's variations in between, but that's what you typically see. So there's a lot to that, but again, the goal is try and get that deal set up front. The other, do you have any tax points of view there?
No, not so much tax points of view. Is it other than I agree with Lance that for Class B members, that the only thing they're entitled to are just their capital. But in terms of the Class B member, is that if the firm blows up, his money is at risk as well as the Class A members. There's some trading firms that that someone would join as a Class B member and think, well, gee, it's just like me trading my own account. I'm getting 80% or 90%. But that particular member's money is at risk in terms of all the other traders.
Right. And one of the things to be careful about, we'll get to in a second, is the whole arcade issue, right? If you're into an arcade, it's one thing to be in a firm where you control. It's another thing to be in a firm where you don't control. And as Phil said, your money is at risk. Now, it may be that the whole firm has to blow up for your money to get sort of taken down, but it's a risk. So that's sort of the corporate tax type of thing, the IP, the employment. The other side, unfortunately, of this business is you can't operate in this business without thinking about regulations. And things to be aware of is under Dodd-Frank, they're now, again, it's targeted at hedge fund managers and private equity firms, but they're now sort of taking away what most firms relied on to be exempt from registration as an IA, investment advisor. And it used to be that if you had less than 15 clients and you didn't hold yourself out, you would have an exemption from registration. So hedge funds often would treat, and they were allowed to, for a limited time they weren't allowed to, but then our friend Goldstein came back, and the end of the day was that a fund was one client. So as long as you didn't have 15 funds or 15 clients, you were okay. Now, many of you are asking why I'm saying this for a trading firm, which isn't a fund. And the answer is, although generally in a trading firm, you wouldn't think that you could see any sort of advisory relationship. You'd be hard-pressed to say the founders are sort of advising the firm or advising the limiteds. The issue is there are some firms that I've seen that will take a management fee or something off of every limited. And once you do that type of thing...
Or a rebate of the commissions.
Right. And once you do that, now management fees not that hard to sort of, if you're at the SEC or the CFTC with a CTA, reconstrue that as an advisory relationship. So you want to be careful with that. But generally, proprietary trading firms don't have to worry all that much about that. The other thing that the CFTC is doing, because why should they be left out of the party, is they have just proposed that they will, in effect, get rid of the two main exemptions that every hedge fund manager or commodity pool manager relied on to be exempt from being a CPO, which is a commodity pool operator. And those rules are 413A3 and 413A4. And what those rules in effect said is that if you were a hedge fund manager and all of your investors were QEPs or QPs, you were exempt automatically from registration as a CPO. And then 413A3 said if you were in effect trading a limited amount of futures, so let's say you're primarily an equities firm, or maybe you're trading a lot of equity options and you're hedging in the futures market, as long as you had a limited amount of futures, you were also exempt. CFTC is proposing to withdraw both of those exemptions, which is going to, in effect, require every hedge fund manager to also register as a CPO if they're trading significant futures. Again, you're probably sitting here, well, how does that impact a trading firm? Again, generally it doesn't, because generally the idea on the IA side where we say we don't see an advisory relationship, on the CPO side, most firms say, I don't see a pool here. I don't see a commodity pool operator, someone that operates, in effect, an investment trust or a syndicate. And the view on the street is that really implies a fund, passive people coming in, having other people trade their money. And so most trading firms will say, well, we're all active, every owner is active, and therefore we're just not a pool. Now, the one thing you should know is CFTC doesn't necessarily agree with your view. CFTC has often forgot that whole thing about investment trust and syndicate and just says you're all trading futures, pooling money, and views a commodity pool. But there are federal cases where the federal courts have disagreed with them and stated, no, 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 we really believe that what this was getting at is a fund or someone who's trading other people's money, not a bunch of active people trading together. So that's the position most trading firms take. Now, the issue for a lot of firms is they start as a prop trading firm and then they want to get a big seat in. Or maybe they start as a prop trading firm, but they need someone to fund money right away. So a lot of firms start with one investor who's not active. And now you're in the gray world, because now we have one investor, and so the CFTC can say, see, I've got an investment trust because that person invested and you guys are trading their money. And maybe the trading firm will say, well, they're still not really a fund. They're really going to have a seat on our board. They're active, and sort of you're in that position where, am I a fund or am I not? So a lot of firms would get conservative and say, all right, if I know I have my investor is a, quote, QEP, I'll go the conservative route and I'll follow this 413A4. Now that option's not there. So now there's going to be a lot more stress on whether you are, in fact, not a pool. So that's sort of at the federal level. On the exchange side, and I'm going to talk mostly about the CME and the CBOT because they have the most complicated fee rules as far as I can tell of any exchange out there. They have various membership categories that you're probably all aware of. Corporate equity members, 106Rs, electronic corporate, 106Js, and so on. And at every level, you have a different fee, right? The more memberships you buy, the more shares you buy, the lower your fee. And so I have a lot of clients that trade a lot of volume where they, in effect, can't make money unless they have the lowest fee. And I have other clients that are in between. Well, the CME, as many of you probably know, have 10 pages of rules dictating what you can do and what you can't do. And most of those rules surround if I have a trader that is a member or someone else who's sort of getting an eat-what-you-kill deal, am I, in effect, selling rates to that trader? They're worried about sort of these arcades where the entity sort of buys the memberships, and then they bring everybody in off the street, let them trade, and sort of give their rates out, and then they take an override, right? That causes a bunch of issues. Number one, besides the CME, you're potentially dealing with the CFTC and the SEC because the question is that person really a prop trader or is that person a customer? And on the equity side, you saw a lot of this, and it wasn't really a rate play like it is on the future side. It was really a leverage play on the equity side. So you had people that either didn't want to become broker-dealers or didn't have the $1 million to become a JBO participant, or they didn't have the $5 million to not be a broker-dealer but trade with portfolio margining. Lo and behold, this other firm had it. And so there are firms out there who say, come on in, we'll give you 100% of your profits and losses. And all we'll do is take a little override and charge a little more than what our clearing firm charges. Seems to me that sounds like what a broker does. It doesn't sound like what a trading firm. Most of my clients that are trading firms make money on trading profits, not on commissions. And for a while, there wasn't a whole lot out there on this. Finally, a couple years ago, a case called Tuco came out where the SEC finally said, yeah, and by the way, we think you're an unregistered broker-dealer. again, this type of framework has always been there on the future side because it's not necessarily people were worried about being an FCM, but the exchanges had rules like the CME because they didn't want you to sell rates. And so now what you're seeing is a lot of the rules on the future side that the CME has put out for rate plays, people are using that as a framework to say, all right, if I want to do a trading firm that allows people to come and go, I need to start taking money or splitting their profits and losses. I can't make money by charging commissions. And I think the expectation is you'll see a lot more enforcement out there in that area. Getting back to the CME, the good news is in the last couple of years, you may not believe it, but their rules have actually gotten better for you. And what they've done is they have started to reduce the share requirements, and they've reduced the amount of money that someone has to have in. So back in years ago, if you were in what they used to call inactive clearing, now corporate equity, in order to sort of have someone in and them only share on their trading as opposed to the whole firm, they used to have 500,000. And I think the CBOT was at 200 for a while. The CME in the last year or two reduced that to 250. And it used to be, for you to become a full corporate member or equity member, you needed to have 8,000 shares for one exchange and then 12 for the next and 16 total for sort of all three, including NYMEX. They've now reduced that share requirement down to 6,000, 9,000, 12,000. So that sort of moved in your favor a bit. The other thing they did is you used to have limits on holdbacks. So if you had an employee, you were not allowed to have a holdback for more than 12 months. Granted, you could roll that holdback. You can do it sort of monthly, keep rolling it. But you couldn't hold that money for 12 months. You used to have to settle up on a sort of period by period in 12 months. They've now gone to 24 months on that. So that's the good news. But their rules are as complicated as ever. And you still have rules that you have to have 80-20. There has to be an 80-20 split. So the firm has to take at least 20. People used to think that the firm could take 20 of the profits but take 0 losses. It's now clear that the firm has to take the losses. You can't just have the trader take all the losses and then it sort of go to the firm if you blew out their account. The main thing that's really come up in the last couple of years is sort of the team trading issue. The CME has a rule which, if you go back years ago, wasn't so clear, but they're sort of understand the eat what you kill deal, that you have one person comes in, they trade their own account, they get their split up to 80 and the firm takes the rest. But what they didn't like, because again, they're afraid of the arcade model, is one person comes in with another person or a bunch of people, and that person takes a split on their trading as well. So what they say is where people are sort of splitting trading. And what you used to see a lot is the arcade model. So you have an arcade, another trading firm would basically lift out, come in as individuals, and the leader of those firms, the two founders, would take a piece of the 80% that the trader got. In order to sort of make that much more difficult, what the CME says is, if you want to do that, you, the person getting a split on other traders, has to get a piece of the whole firm. Well, as you can imagine, that's not a problem for the supervisor, but it's a problem for the firm because in their mind, they can't even contemplate how they're splitting the rest of the firm with that person. And generally, the CME wants to see a split based on capital, something they can sort of see. The problem is generally most firms won't split based on capital. They'll want to split, give someone a tiny little piece, and the CME won't necessarily buy that. So that's a problem. There are a couple ways to deal with that. One way, which they have in the past said is okay, is if they're focused on the tax treatment. They're focused on that supervisor getting the 60-40 treatment. So they have in the past said, potentially, if that supervisor gets W-2, or not W-2, but sort of ordinary, whether as W-2 as a guaranteed payment, we'll allow them to split on the other traders. We don't want them sharing the tax treatment. So that's one way. But it's a real issue for firms that team trade. Because a lot of my clients team trade, and they can't do a definitive split, right? Because you have 3 traders, they're all trading, no one knows where the profits are coming from, one guy's hedging or whatever, and so the 3 teams says, we're happy to have the firm pay us, either discretionary for all 3 of us, or tell us you're going to pay the 3 of us 70%, we'll be happy to sort of figure out how to split it up. That is, in my view, an extremely legitimate form of trading. And in fact, you could argue it's more pure than other forms because you have traders willing to not have a definitive split on their trading and to trust the firm. The problem is that gets caught up in the CME's rule, because if from their view you have traders splitting and they see sort of arcade. And I'll be honest, we haven't had worked out a great solution to that. We've tried to get solutions where one guy gets K1 and the other guy gets W2, and they don't really like that either. So if you're team trading, it's a bit of a challenge without trying to figure out a way to have that team split on the rest of the firm. I think that's probably gone over, and that's sort of the highlight of their fee policies. But they're very detailed. There's a lot of things that you can't do that you may think you can do, and so it's important to sort of know those policies, because you don't want to necessarily come up on a CME audit, have them go through, and you're violating their policies, because they have authority to not only go back and recharge at customer rates, which often would mean you owe them money, but they have the ability to levy a hefty fine. So you want to make sure you're on the front end of that. And if it's gray, a lot of times what we'll do is we'll go to the CME, we'll get clarification. We want to know if we're going to do something. We're not going to wake up in 2 years with an audit and owe a bunch of money. So that's it, I think, on the exchange requirements.
I can say in most of the trading firms that we've worked with that have been set up in the last few years, and assuming they're a member firm of the CME, exchange fees is really the driving force. Right? I mean, just because the magnitude of the dollars involved.
And again, on the equity side, it's typically the leverage issue. How do we get leverage?
Any questions? Over there, this one.
I think as everyone can attest, these guys are the experts in this area, and they're a great resource. They've been a great resource for Advantage Futures and quite a number of our clients. So I encourage you to reach out to them sort of outside of this seminar if you are interested in getting more information. So thanks again for attending.